Welcome everyone, and thank you for attending the third webinar of our series about the future of Alberta policing. My name is Doug Dirks, and if I look familiar to you or my voice sounds familiar, there's a reason for that. I've recently retired from CBC Calgary after 3 decades. The last 10 years in the host chair of the home stretch on CBC Radio 1, the afternoon current affairs program. And during that time, I also spent a lot of time emceeing and moderating events for organizations like the Canadian Mental Health Association, the Special Olympics, and 2 of the institutions I attended and graduated from, Mount Royal University here in Calgary and also McGill University in Montreal. So we're really looking forward to hearing what our panelists have to say, your questions today on this topic. But before we begin, I'd like to go over a few of the housekeeping items that will keep us on track. Now, as you hear from our panelists, we invite you to submit your questions anytime using the Q&A box on the right side of your screen. It's as simple as typing in the question and hitting the send button. And following the presentations, I'll relay your questions to our panelists, and we will do our best to compile and answer as many of your questions as we can within that 30-minute time frame. Our session this morning will explore why police governance and civilian oversight matters. Effective police governance and civilian oversight are an integral part of an accountable and transparent police service. This morning, our speakers will discuss why they matter in the wider context of community policing. And today's session panelists include Kent Roach. Kent is a professor of law at the University of Toronto. And prior to his current role, Kent served as a law clerk to Supreme Court Justice Bertha Wilson. He has served on research advisory committees, for the Arar and Ipperwash inquiries, which reviewed police conduct. Kent is also a member of the Order of Canada and a published author. His most recent book, published this year, is called Canadian Policing: Why and How It Should Change. Kent, thanks for joining us this morning.
Thank you.
Our second speaker is Ryan Teschner, and Ryan is the Executive Director and Chief of Staff of the Toronto Police Services Board. He has served as Special Counsel to the Deputy Minister of Community Safety and Correctional Services and the Ministry of the Attorney General. In that role, he designed and led the development of Ontario's new policing and oversight legislation, along with other initiatives to modernize policing in that province. Welcome, Ryan.
Thank you very much. Good morning.
And I'll now turn the floor over to our first panelist, Kent Roach, for his presentation.
Well, thank you very, very much, Doug. It's wonderful to be here. I'd like to acknowledge that I'm speaking to you from the traditional homelands of the Mississauga of the Credits, and I'm happy to work and learn from all various Indigenous people that have been on our lands. So I'm going to talk about governance and oversight, and I'll probably start off with a kind of distinction between governance and oversight. They both are important in Canadian policing, but really the central thesis of my book, and this stems both from my time with the Ipperwash Commission and also time with Canadian Council advisory panels, expert panels on policing and policing in Indigenous communities, is that we have focused more on external and often legal forms of oversight that are often about deciding after the fact whether the police have acted in a proper or lawful way. And I don't in any way want to diminish the importance of that. I am a lawyer, and that is critical in order to have the rule of law in which the law applies to everyone, including the police. But that said, the central thesis that I'd like to get across today, and I think if you look at my book, you'll find is also reflected in my book, is that there is a governance deficit in policing in Canada for a variety of reasons. One reason is that governance of policing is very divided. Obviously, the RCMP contract policing is one example where an RCMP detachment may have to answer to Ottawa, answer to Edmonton, and answer to a local policing committee formed under the Alberta Policing Act. And sometimes if you have 3 bosses, you may have no bosses. And I think that is especially true because police government relations in Canada remains a very fraught area. And of course, we've seen this most recently in the controversy surrounding the Nova Scotia investigations. Was there political interference or was there not? So I think that the divided nature of governance in policing, which is, I think in part a product of federalism, and even under an Alberta provincial police model, would still to some degree continue in between the province and the locality, but is obviously complicated if we're talking about RCMP contract policing, or if we're talking about Indigenous policing, where you enter into a third or even a potentially fourth level of governance. And so really, the central message that I want to leave with people today is that, whatever happens with this proposal, I think it is positive if it gets us thinking about more democratic forms of policing. And, much like my work in judicial review and on democratic dialogue, I say this knowing that I will not always be happy in my personal views about where democratic policing may take us. But I do think that in a democracy, policing is much too important to be left essentially to the police, because my concern is that we are in a situation where the police, whether it be municipal or regional police, provincial police, or the RCMP, are, for a variety of structural reasons that I've already alluded to, essentially too often left to govern themselves. So with those kind of preliminary remarks out of the way, I do want to talk a little bit, though, about the oversight piece and how that might change or not change if an Alberta provincial police model was adopted. The first thing is that Robert Christmas, who has written about policing and is also still an active officer on the Winnipeg Police, has talked about police facing quadruple jeopardy when it comes to ex post accountability mechanisms. And again, I'm not saying that that's wrong, but I think that Mr. Christmas is right, and in fact, it could be beyond quadruple jeopardy. So the first thing to note is for the public, we are increasingly looking at what in Ontario is called Special Investigations Units, in Alberta, the ACERT team, as really probably the most high profile form of accountability. And I go through in my book the pluses and minuses. Suffice it to say, as a criminal law professor, that's my primary occupation, I find it not surprising that in the vast majority of cases, no charges are laid. Police officers, like everyone else, have a right to silence. They're probably better positioned to exercise the right to silence than many, and should only be charged with a criminal offense if there is a reasonable prospect of conviction. And of course, our laws of self-defense are, quite uncertain, but the Supreme Court of Canada has told us in the Nazagalowick case in 2010, interestingly cited by the New Brunswick Attorney General as a reason not for prosecuting police officers involved in the killing of Chantal Moore and Rodney Levy, two Indigenous people in New Brunswick that were killed by police officers in June of 2020, that the police are not to be held to a standard of perfection. So there is a lot of pressure on these independent investigators. I note that the incident with Chief LL.M is, I believe, still subject to investigation. I've looked recently to see if ACERT has completed that investigation, and I'm sure people will correct me if I'm wrong. But this is part of the rule of law, but I see no kind of tangible evidence that it is improving policing ex ante, or even that it is critically examining our use of force policies that the police use. And my own view, for what that is worth, is we've had far too many deaths in Canada caused by the police when people, often in mental distress, refuse to put down sharp-edged objects. Second, we have disciplinary offenses. And again, if you look at my book, you will see that I am, pretty skeptical about what we obtain through the enforcement of disciplinary offenses through the police. So I'm probably in the camp of those who want the police to move to a regulated professions model, perhaps including a college of policing, where the regulatory process is more like the regulatory process that nurses and lawyers and doctors undergo than what we often have in Canadian provinces, which is this kind of mix of the remnants of a paramilitary policing discipline model and what has become too often a quasi-criminal trial, where police officers are often well represented by seemingly very well-resourced criminal defense lawyers, often paid for by policing unions. And of course, with the RCMP, the Brown Task Force way back in 2007 criticized the RCMP discipline model. There have been some changes, but Commissioner Lucky has admitted in her testimony before the mass casualty inquiry that she's not always happy with the results. Again, this may be surprising given that I earn my living training lawyers, but I find that lawyers have not always made this discipline process for the better. And when I read RCMP discipline decisions that are over 400 paragraphs long, I really think we have overshot the mark, and certainly not showing signs of moving towards what the Brown Task Force, which did include two former commissioners of the RCMP, recommended, which was more of a kind of, employment remedial sort of approach. I also think that many of the sanctions that are used in the disciplinary process may not command public confidence. So if a police officer is found to have breached a code of conduct, committed a disciplinary offense, taking 10 days away from him or her, days off, may actually make the problem worse. Because of course, police officers, like all first responders, have extremely difficult jobs, and often disciplinary offenses are signs of larger well-being issues with the officer, or the need to take remedial action, which may not mean actually working more, but could mean working less. The next level is policing complaints. And I think this in some ways is perhaps the most relevant to the debate about whether Alberta should move away from contract policing. Because the Rcmp Act now, I guess in an act of cooperative federalism, has made the Rcmp subject to ACERT jurisdiction when it comes to serious injuries or deaths and criminal investigations. But the Rcmp is still subject to the discipline, to complaints that are in the vast majority of cases investigated by the Rcmp, but reviewed and can be the subject of a chair-initiated complaint by the Rcmp Civilian Complaints and Review Agency, which is in Ottawa, and frankly does good work, but is somewhat remote from those from the contract policing role as it is exercised from coast to coast to coast. Here, I want to talk a little bit about Bill C-20, which is before the federal parliament, which I think will place strains on the ability of the Civilian Review and Complaints Commission. So as we know, there's about 19,000 Rcmp officers. Most of those are involved in contract policing. So the Rcmp review body, civilian review body, which will be renamed in C-20, which is fine. Names are important, but they only get you so far. Is now going to be added jurisdiction over complaints with 5,000 Canadian Border Service agents. And of course, there needs to be a complaints body for CBSA. They are the largest armed force in Canada not subject to civilian oversight and complaints. But I'm not so sure that it should be the same body that exercises jurisdiction over the Rcmp. One of the things that I think that the Rcmp complaints body does very well is it examines systemic issues. It examines systemic issues such as strip searches, finding that the Rcmp, like some police forces, have struggled to implement the golden restrictions on strip searches. Most recently in the CBC, there's been an interesting article about the Rcmp's handling of sexual assault cases based on work from the Civilian Review. My worry is that as the jurisdiction of that body increases to the CBSA, and we have seen this in Ontario, the first thing that goes is the ability to conduct systemic reviews. Now, this is not to say that Alberta's LIRA, Law Enforcement Review Agency, is necessarily better. So I am aware that it did in the Arkansas inquiry conduct a more systemic inquiry, but it doesn't seem to feature in much of its work. And so if Alberta moves to a new policing model, my recommendation strongly would be to give a review and complaints body jurisdiction to do systemic reviews, because frankly, systemic reviews, in my view, have a better chance of improving policing ex ante, which is not to say that we should abandon the ability of civilians to make complaints against the police, but we probably shouldn't expect too much. Another thing that I think is relevant to the debate here in Alberta is that the Bill C-20 does allow the provincial minister to ask that specified activities be examined by the civilian review complaints, but the minister has to go through and, on my reading, obtain the permission of the federal minister. And as we know, the civilian review and the RCMP's response to it has been bogged by delays, and this is another kind of sticking point. Finally, I should just say, as a constitutional lawyer and as the co-biographer of Brian Dixon, that we should also note that Justice Dixon dissented in the Putnam case, decided in 1982 from Alberta. He also dissented in Scobie and Glendenning, and really had concerns that the RCMP, because as a Westerner, Brian Dixon appreciated the important local policing role of the RCMP, something that is not generally appreciated where I live in the center of the universe, Toronto. Brian Dixon knew that the RCMP were kind of the frontline local police. And so I think his warnings of the danger of the RCMP being wrapped in what he colorfully and eloquently referred to as a federal cocoon are, really coming home to roost in the debates that we're seeing not only in Alberta, but in BC and in New Brunswick and perhaps elsewhere about the need for a provincial police force. Okay, so I've spent a lot of time, and I know I only have about 7 minutes left, talking about oversight. And so you might think I've repeated the same mistake that I warned against at the beginning about not talking about governance. But in fact, there is, I think, a lot less action, unfortunately, in governance, although I anticipate that Ryan Teschner, as part of, one of the most active civilian governance bodies, will fill in some gaps. But let's start with the RCMP. The RCMP is really subject to this bare bones governance model that is articulated in Section 5 of the RCMP Act, which says simply, the Governor General and Council may appoint an officer to be known as the Commissioner of the RCMP to hold office during pleasure, who, under the direction of the minister, has the control and management of the force and all matters connected with the force. Well, that is probably the key provision in the RCMP Act. And I think from a provincial perspective, and also from a citizens and government perspective, it is rife with problems. So first of all, the commissioner, and through them, the Minister of Public Safety, has control and management of the force and all matters connected with the force. So whatever role the provinces and the localities can assert through the contract policing is really subordinate to this idea of federal control. Now, I do recognize that there can be provincial input, and some provinces and territories like the Yukon have come up with transparent modes of governance. So in the Yukon Police Council, I think, is a model to be looked at if contract policing is retained, where you have a 6-person police council, including the Deputy Minister of Justice, who of course plays a key role in negotiating with the feds on contract policing, and 3 people nominated by First Nations in the Yukon. But really, outside of the Yukon, the way that the provinces and the federal government interact over contract policing is, from a citizen's perspective, not transparent. Second, way back in 2001, Justice Hughes, as part of his APEC review, said, and the Ipperwash inquiry in Ontario also made a similar recommendation in 2007, is that we need to codify police independence. So contrary to what some may have you believe, I'm not a complete skeptic about police independence. I believe in police independence as Justice Hughes and I believe Justice Morgan contemplated, and is contemplated in the 1999 decision of the Supreme Court of Canada in Campbell and Sherrose. We don't want to live in a police state where any political authority can tell the police whom to investigate and whom not to investigate. However, and this also follows from the MacDonald Commission way back in 1981, I believe everything else can be subject to political direction. But I think that we need to codify legitimate core police independence, that is the law enforcement discretion, and then, as the Ipperwash inquiry recommended and has been belatedly recognized in still unproclaimed policing legislation in Ontario, provide that whatever the accountable political authority is, whether it's the responsible provincial minister, whether it is the local commission, or whether it's the federal minister of public safety, that that body can direct the police, but through transparent directions. And of course, we don't know what the ministerial directives are that guide the Rcmp. I made an access to information request while I started my book in 2020. I'm still waiting for a response. So I think that we're obviously at a critical juncture in policing in Canada. One of the reasons why I wrote the book is that I wanted to contribute to this in a way that hopefully is independent and fresh. And I think that whatever happens, the Rcmp Act needs to be changed, because we're in a zone now where everyone, including apparently the mass casualty inquiry and the federal minister, is talking about operational independence. And the problem with that phrase is operations is only found in 2 police acts, and it's far too broad a definition of police independence. If the police have independence over all operations, and if they particularly have independence over the policy that guides in operations, then I fear we're living in another type of police state, and that is where the police answer only to themselves. Now, I don't say that to be inflammatory. I think we have generally benefited from enlightened police leadership in Canada, but we cannot assume that that will always be the case. And so I think it is urgent, whether we remain with Rcmp contract policing or we move to new models, that we codify legitimate core police independence and also provide a means for the police, those with responsible authorities. The last thing that I'll say is I think we also have to question whether the responsible political authorities should just have responsibility for the police. So the latest movement, and this is partly embraced in some of the recommendations for an Alberta provincial police that I've seen and I endorse, is to move towards a more holistic community safety and well-being approach. If we're going to do that, then I think we do need to think about how are those represented in the governance of the police, because we can't knock down silos when it comes to community safety if policing governance remains in its own silo, particularly in a situation where, given the lack of clarity and often controversy over police-government relations, politicians may fear to tread. So thank you very much for your attention, and I look forward to trying to answer any questions that you may have.
Kent, thanks for your presentation and your insight and your expertise on this topic. And as Kent mentioned, both Kent and Ryan will be taking questions for about 30 minutes after Ryan's presentation. And all you have to do is go into that Q&A box and pose your question, and we'll get to as many as we can during that half-hour session after Ryan's presentation. And our next presenter is Ryan Teschner. Ryan?
Thank you very much, Doug. And Kent, or Professor Roach, as I called you in my first year criminal law class, always good to hear your thoughts and your insights on this topic. I'd also like to acknowledge that I'm speaking to you from the city of Toronto, and that we're on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and the city is now home to many diverse First Nation, Inuit, and Métis people. The City of Toronto also acknowledged that Toronto is covered by Treaty 13 with the Mississaugas of the Credit and the Williams Treaties signed with multiple Mississaugas and Chippewa bands. So good morning to everybody. My name is Ryan Teschner, and I'm happy to be with you today and to talk to you a little bit about the future of Alberta policing and contribute as I can from my perspective and the seat that I occupy, providing my perspective on infusing any future model with what I believe are some essential ingredients for healthy and modern independent civilian police governance and oversight. And I think this is an exciting time for Alberta to be taking a look at its model. I want to talk to you today about the why of governance, the philosophical and legal underpinnings, the how based on recent experience here in Toronto, and what I view as some of the essential pieces for the path forward. And Professor Roach talked about the deficit in governance. And I'd like to think that here in Toronto, and as I've been seeing some of my colleagues in other boards and commissions across the country, we are starting to see some of the paying down of that deficit. So let's talk a little bit about the why. Trust and legitimacy is an endemic within our public institutions. And recently, the Institute of Corporate Directors published their trust index that found declining levels of public trust in all 5 institutional groups. Yes, business, media, not-for-profits, and charities, but importantly, in government. Next slide, please. So trust is, in my view, the secret sauce of police governance. It's the outcome that we should be seeking to achieve. It's the fundamental part of the recipe we're all involved in creating. And this same research found that companies considered to be industry leaders within their sector regularly outperform on the basis of that trust indicator. And so trust is the thing I think we should be chasing. And so my thesis today is that modern police governance, and I'll unpack a little bit about what I say that means, creates the connective tissue for repairing, enhancing, and building trust in policing. But this needs to be a deliberate pursuit of boards. And so there are 4 things up on the screen that I think good governance helps us create in terms of public trust. Yes, governance in some form of policing requires something separate from the police exercising their law enforcement decision-making. It takes the politics potentially out of policing if law enforcement decisions are not made or directed by those elected to hold office. It can create an intermediary, a way to translate public values and expectations into the framework within which policing occurs. And good governance can create a mediation or even sometimes arbitration mechanism where, yes, you engage with stakeholders, you hear their views, but ultimately an independent arbiter makes the decision. Next slide, please. So Ken talked a little bit about oversight and governance, and I would say that they are two sides of a coin. The governance component is proactive, it's forward thinking, it's the policy and legal infrastructure that this independent group puts in place, and that becomes the arena within which police services are delivered. And then, of course, importantly, you have the accountability component, fulfilled by, in Ontario, the different groups, the Office of the Independent Police Review Director, who investigate and oversee public complaints against the police, for example. That accountability component is the after-fact review, where particular decisions or acts that have already been taken are examined after they've occurred to determine whether there should be accountability or lessons learned. But both of these components are aimed at ensuring the delivery of good, legitimate policing that inspires public trust and confidence. Next slide, please. So let's talk a little bit about the legal context of policing, municipal policing in Ontario, as a conduit through which we can talk about some of these broader contexts. In the Ontario municipal policing context, we have neither the models identified by Professor Roach as a government policing model or a police state, full independence policing model. To understand the operation of modern civilian governance and oversight in Ontario, I want to talk to you about Toronto. The Toronto Police Service is a large organization with over 8,000 employees, but the service actually has no capacity at law. The service is essentially an amalgam of policing services provided by thousands of individuals and independent public office holders, supported by thousands of civilian members. And the service operates in a distinct legal environment with a unique structure that's evolved around what some people refer to as the tension between the independence of the constabulary and civilian governance and oversight. Next slide, please. So let's talk a little bit about the independence of the constabulary. A police officer in Canada holds original authority derived from the law and not indirectly through a minister or a municipality. And one of the most famous cases that, if you grew up through law school under Professor Roach or otherwise, you'll hear quoted, is the decision of Lord Denning in Blackburn. A police officer is not the servant of anyone save the law itself. So the independence of the constabulary is meant to ensure policing without political or other interference. And there are plenty of Canadian examples where these principles were tested, explored, and reviewed. And Professor Roach talked about some of them: the Ipperwash Commission, the MacDonald Commission, and others. And Kent also talked about the Campbell and Charot's decision from the Supreme Court of Canada in 1999, remaining today the legal authority, the leading legal authority on police independence. But it stands for a proposition that sometimes gets overinflated. The principle that it seeks to uphold is that there is a protected core of police independence over law enforcement decisions. But remember the other side of the equation. Against the notion that political interference in policing must be guarded against are examples where civilian governors, knowing perhaps too little or not playing the role that was intended, create its own set of concerns. In other words, too little governance is a problem. Next slide, please. We're going to talk about boards and commissions in a second, but let's talk about the chief of police. To flesh out that landscape, you have to understand this other actor on the policing landscape. Here, in the context of Ontario municipal policing, the chief is hired by the Police Services Board, and he or she have their own statutory duties. They administer the police force and oversee its operation in accordance with the policies of the board. Remember, I talked about that arena of policing that is framed by the civilian governors. They ensure that members of the police force carry out their duties in accordance with applicable legislation and regulation, and in a manner that reflects the needs of the community as articulated through the board's priorities and objectives. And of course, the chief is required to comply with the lawful directions of the board. So the chief reports to the board and is accountable to it. And the chief then establishes procedures or the day-to-day operations in line with the board's policies and objectives. Next slide, please. But alongside independence is governance and oversight systems premised on accountability internally for the decision made or the actions taken or not taken. In other words, the structure within a police service, the rank structure that call for officers to answer to their superiors, the code of conduct that if breached can lead to disciplinary action, proceedings, and in extreme situations, termination. Individual officers being answerable to the law, either through tort, as well as charter and human rights code law. And from a broader perspective, the fact that police operate within a legislated structure meant to balance the independence of police with the need for civilian governance, oversight, and the public accountability that hopefully comes with it. So on the next slide, we move to talking about the board, the other actor on the landscape. Civilian governance and oversight exists for every municipality that maintains its own police force in Ontario. Civilian oversight and governance is the mechanism through which the public's accepted values and norms can guide the delivery of police services. The board or commission in some jurisdictions is meant to maintain that balance between that core independence of the police function, the decision-making authority that police require to engage in their functions in a constitutional democracy, and on the other hand, creating an effective framework of policies, legal requirements, resources, and operational leadership in which the specific law enforcement decisions will be made or taken. And so their statutory responsibilities include ensuring adequate and effective policing in the municipality, appointing the members of the police force, determining after consultation with their policing expert, the chief of police, objectives and priorities with respect to the delivery of police services, approving the budget, that is the resources allocated to the police services, establishing policies for the effective management of the police service, recruiting and appointing the chief and deputies, and directing the chief and monitoring their performance. So the board's primary responsibility is to create the governance infrastructure of the police force and direct the chief without encroaching on that core area of independence, but certainly placing the parameters around it. Next slide, please. And so the police board must do this within certain legal limits. And I've talked a little bit about the statutory, the constitutional limits. And so while all members of the police force are under the board's jurisdiction, another important limit is that the board may only give orders to one individual, and that is the chief of police. That is the individual that they can provide direction to through policy or otherwise, and the chief, as some people call it, operationalize that policy direction through the direction they provide day to day to the police service. Now, this has been a classic area of misunderstanding since 1990's Act here in Ontario. Classically, this piece of the Police Services Act that says that the police board can only provide the chief with direction, but not with respect to specific operational decisions or the day-to-day operation of the police force, has, in my submission, been misinterpreted and misapplied. And so this impermeable shield that has classically existed, that has caused certain police services and boards over time not to share operational information, has contributed to the view that boards cannot create policies that in fact impact the delivery of police services, these are wrong. Next slide, please. And so what some people have called a healthy tension, I would suggest really should be seen more as a symbiosis. And let's go back to grade school science. Symbiosis is an interaction between two different organisms that can create positive effects or outcomes for both. And in my submission, the chief of police and the board are these two different organisms. And the positive outcome that good governance, understood within the context of the parameters in which it occurs, can contribute to enhanced trust and legitimacy in the context of how police services are delivered. Next slide, please. But this means that we have to move past this idea that it is policy versus operations, that these are watertight compartments, as Judge Morden in the G20 review said they are not. That's where this tension has historically arisen, in this idea that you can define what is policy and that it is always separate, apart, and can't impact too much what are operations. Importantly, it's also contributed to a gross misunderstanding of whether or not the board can in fact even get information from the chief about what's going on in the police service that it governs. And so the Ipperwash inquiry talked about this distinction as being fuzzy. And in my experience, while some progress has been made, this old framework of policy versus operations is still alive and well, perhaps more than it should be. Next slide, please. And so instead of this idea of versus, I talk about policy and operations. And I think this is the view of Judge Morden, expanded upon more recently by Judge Epstein in the report Missing and Missed. Understood this way, matters of policy and operation are not separated into watertight compartments. Policies and directions must impact the delivery of police services. And in his seminal report in 2012, Judge Morden clarified that a board is only precluded from giving direction concerning specific operations, that core of law enforcement activity. For example, it cannot order the chief to undertake a specific investigation into a specific person or group of people. It cannot order the arrest of a specific individual. But what it can and must do is create the governance infrastructure through policies, legal direction, and otherwise that should and must impact the way operations in policing are delivered. And in fact, Judge Morden said a board will not fulfill its function if it does not do that. And so more recently, and I'll talk about this shortly, in Toronto, we have taken Judge Morden's and Epstein's views to heart. And in the policies that we have put in place and our board has approved through some of the other more critical events that our board has been engaged in with the chief, I think the board is moving to this modern approach. Now, in terms of accessing operational information, as some people call it, which really could be any piece and every piece of information that a police service has, this is another area that's historically been seen by many as out of bounds for civilian governors. And Judge Morden here confirmed too, that without access to all relevant information, including that core policing information that is sometimes protected to the highest extent, the ability to ask questions about operational matters, the ability to have a to and fro without interfering in that core policing function, the ability to actually understand the impacts of the policies or legal infrastructure you put in place is compromised. And so boards and commissions must have access to this operational information in order to engage in their statutory function. Next slide, please. Now, Kent talked a little bit about the Community Safety Policing Act that has been adopted in Ontario but has not come into force yet. And there are some areas in which this act seeks to modernize the governance function of boards based on the lessons learned by Judge Morden. It clarifies the board's ability to direct the chief of police, including in section 38 sub 5, that a board cannot make a policy with respect to specific investigations, and the conduct of specific operations, or the management of discipline of specific police officers. It also requires boards to create a 3-year strategic plan, moving away from the annual business plan that they currently put in place, and requires, importantly, engagement not only with the chief of police and the service, but consultations with a varied number of entities, groups, and stakeholders, as well as consideration of community safety and well-being plans adopted by a municipality. Now, it remains to be seen how these legislative provisions come into life, but these are areas that I believe signal an intention to clarify the modern governance mandate of boards. Next slide, please. So for the balance of my talk, I want to actually try and put some life to these concepts and talk to you a little bit about how the Toronto Police Services Board's journey to modern police governance has been going over the last several years. There are many ways and areas that we have focused on. The information exchange that needs to exist between a board and a chief of police in formal ways and in day-to-day informal ways. More clarity and common understanding between a board and a chief about what constitutes a critical point and the special duties and obligations that come to the fore when one crystallizes. And I'll talk more about that later. Fundamental changes in the approach that we have taken to the development of board policies, making policies true legal direction that create the parameters or the arena in which police operations occur. And we've done this in the areas of race-based data, body-worn cameras, artificial intelligence in policing, and several others. The professionalization of the board's function through a professional staff in the board office that can create independent sources of expertise and perspectives that allow the board to have more input than they classically do. And establishing formal links to communities and communities of interest through board advisory panels, public engagement sessions, and other mechanisms. Now, I have a few other insights from my perspective. First, the flow of information to the board cannot and should never depend on the personal relationship between any one chief and any one board chair or board member. And so here, I believe the institutionalization of the board's modern governance function is something we need to double down on through legislation, but also, as I mentioned, through the professionalization of the infrastructure that supports boards in a day-to-day way. Secondly, culture must be one where the chief recognizes the board's role is not an imposition, but that properly executed on proper information can only improve the delivery of police services and therefore the trust and legitimacy the public has in its police service. Third, boards must do a better job of engaging their subject matter experts, the chief and the service, to understand the operational impacts of its policy decision and use that as one important impact or input in guiding its decision making, but also recognizing that proper engagement with other experts, whether they be academics, sector experienced folks, persons with lived experience, or members of the community, is also essential. Fourth, formalizing in some fashion a critical points policy or approach and understanding so that this baseline is maintained regardless of the particular people in the particular chairs at any point in time. So this breadth and depth, I believe, over the last several years has created more recent initiatives that evidence here in Toronto a more modern approach to police governance and oversight in our policing reform recommendations, in enhancing public reporting to the board based on analytics, in the formalization of performance goals and objectives and an evaluation process for the chief and members of command, the annual budget process and the evidence-based approach that has been undertaken there, various legal agreements and MOUs with independent individuals, including the city's Auditor General, to give them an opportunity to come in, look, and provide recommendations to the board, and identifying better reputational issues and collaborating to manage them in the public interest. So let's talk about one concrete recent example on the next slide. A case study in our own Toronto experience with respect to the 2002 Freedom Convoy. This was, as Judge Morton talked about it, a critical point that gave rise to a certain set of obligations around information sharing and transparency and the board's governance role. So how did we determine this role was triggered? Well, there was a constant flow of information between the chief, myself, and our office around the lead up to this convoy, what was happening in Ottawa, and what the police service here in Toronto was learning about it. It gave us the ability to create the governance awareness, the real-time governance awareness that helped determine when an organizationally significant issue was going to occur. And so it became less a reliance on the chief throughout the process, although the chief triggered it initially, and more a natural reaction to the constant information flow that allowed us here in the board office to determine when the board should be engaged to perform its governance function. And so when we felt that it was at that time, we called a special meeting of the board. And in that meeting, the chief provided the service's full operational plan, the key context for the major event in operation that animated the planning decisions that were taken, including hate and terrorism related threats, the priorities and objectives that had been identified for this specific operation, including here in Toronto, maintaining access to what we call Hospital Row, so that patients, medical professionals, and visitors could access medical care unencumbered, and at the same time, ensure that those who were here to protest and assemble could do so and express their views peacefully. Confirmation of board policies and existing legal authorities to provide the adequate framework for this major operation, including any specific elements like contribution agreements where we were going to rely on resources from other police services. The adequacy of the staffing and operational capability for the procedure was also something that was discussed with the board. The command and control approach that would occur here in the city, given that there would be other police services and actors on the landscape, and the adequacy of the general policing service delivered by the Toronto Police throughout the rest of the city, separate and apart from this specific operation. And finally, public communications, so that members of the public would be advised as to what was happening and, where possible, be told why. All of these areas were covered in this discussion, this meeting between the board and the service. And after the meeting, the board issued a public statement advising that it was fully briefed, had access to all of the information that was relevant, and that it was, quote, supportive of Chief Ramers and the service's plan and the extensive work that is underway to provide adequate and effective police services this weekend. Uniquely, here, we also created a different structure. There was, after this meeting, a management table that was created with all of the partners. The chief was the chair. It had the City of Toronto, the city manager's office, the mayor's office, and others, and a seat as the board's representative for me, so that in real time, I could hear how the operations were unfolding, whether any changes were being contemplated, how the service was reacting to new and emerging information, and make an independent decision about whether the board's governance function needed to be engaged again in light of the changing landscape. Fortunately, in this case, that was not necessary, and the plans as conveyed to the board originally were the ones that were put in place and implemented. Next slide, please. There's a couple of other areas where we're also taking a modern approach, and I'll just cover these quickly. Public consultation and engagement directly by boards, not by police services on behalf of boards, but directly by boards, is something that we are also doing in a variety of key public policy initiatives. 4 days of public consultation hosted by the board back in 2020 led and were some of the key inputs to creating the board's 81 police reform recommendations. Not a consultation held by the police service, but one that was actually activated and held by the board. And there are two other ways that we're doing this on an ongoing basis. The board has 2 permanent advisory panels, an anti-racism advisory panel, whose mandate is to advise and support the board in relation to policing and racism, anti-Black racism, and anti-Indigenous racism issues, and a mental health and addictions advisory panel, also permanent, that looks at mental health and addictions issues in the policing context. Next slide, please. On the policy development side, we've also taken a more modern approach, and this has led to the board office taking evidence-based approaches to the development of policies, informed, yes, by the operational realities as we learn of them through the police service, but also by these various inputs provided by our advisory panels, independent research, and other stakeholders that we engage. And this is an area that boards have traditionally not been able to invest in. And I would encourage this be an area of some thought leadership. Any police board or commission who has to develop legal direction through policy should have the professional capacity to do that independently and not rely entirely on the police service for perspective. We've done this in a variety of areas that I've mentioned to you earlier. More recently, race-based data policy, body-worn cameras, artificial intelligence in policing, budget transparency, recruitment, hiring, and promotions, just to name a few. But importantly, on the next slide, you'll see we've done this in tandem with the police service. And so as our office develops policy, we kick the tires of it with the policing experts so that we can understand how certain policy directives may have certain operational impacts and make credible evidence-based decisions when we're advising the board about where we ultimately land. And this policy development approach is itself, in my view, an information exchange. Next slide, please. And so effective governance and oversight done in this modern approach demonstrates, I think, that independence and independence of data and analysis is the key. The board does not have to be dependent on the police service in deciding what information will be collected and how it will be reported. It can, through the right tools in its toolbox, do that itself. The board doesn't have to be dependent on the service for the actual analysis of the data either. That's not to say that the service shouldn't put forward its own analysis, but the independence of the governance function, I believe, necessarily requires that boards and commissions have the capacity to do some of that itself. And thirdly, the board can and should make decisions about what information will become transparent and accessible to the public so members of the public understand how the board arrived at the decision that it made. And so lastly, let's talk about the next chapter of this evolution and modernization of governance. I believe that we are moving from an output-focused approach in governance to an outcome-focused approach. In other words, making governance and oversight not merely modern, but more effective. And in doing so, making policing more effective and therefore enhancing trust and legitimacy. And so in the age where community safety and well-being plans are being developed together with multiple stakeholders, and we have a better understanding now more than ever perhaps of the importance of identifying key risk factors within a local community and being strategic in how to address them so they don't become acute elevated areas of risk, we require more intensive, sometimes expensive, and long-term interventions between boards, police services, and this landscape of community safety partners, allowing boards to use their entire governance toolbox of policies, directions, budget allocation, command evaluation, to move the dial of the discussion to identifying what community safety outcomes we are seeking to achieve together and being able to measure and evaluate progress against them. And in this way, those who independently govern and oversee police services will finally and truly be fulfilling their mandate to bring the needs and expectations of the entire community and the police service into focus so that police resources are deployed and services are delivered together with other partners in a manner that best enhances long-term community safety and trust. And so there are three quick things I will suggest should be the focus of the next chapter as we modernize. As Ronald Reagan put it, trust but verify. Data, analytics, and evidence-based approaches has to animate board and commission decision-making. Second, make the governance and oversight work of boards and commissions more transparent and understood by the public that we serve. And thirdly, good governance and oversight needs to be properly and professionally resourced. That's a little known secret in the police governance world, but the reality is board members often are part-time. They need a professional staff, not unlike a ministry, to help them deliver on what I believe to be an expanding and important mandate. And so as you embark on your work here in Alberta, I'd urge you to take these and other things into consideration. And I thank you for your time today.
And Ryan, thank you so much for that presentation. And that'll bring us now to the question and answer portion of this webinar. And as we mentioned previously, if you have a question, just go into the Q&A box and pose it. We'll do our best to get to as many of them as we can here in the next 30 minutes or so. So Kent, why don't we start with you? We have this question for you. Why can't the RCMP simply change its governance and civilian oversight model to be more like a modern police commission in contract policing jurisdictions?
Yes. Well, thank you. That's a good question. And Ryan, well done. I hope I gave you an A. So, anyway, so yeah, I think one of the problems is just the sheer size of the RCMP. So I didn't get a chance to talk about the Management Advisory Board, but the Management Advisory Board at the RCMP, which was recommended by David Brown way back in 2007, I think was only set up maybe 2018, really has not become an equivalent of a national police board. And although it has the possibility of going to the minister, it doesn't seem to do that in a transparent way. And it also, to my knowledge, doesn't have the sort of professional ministerial help that Ryan talked about, which again, I think is absolutely essential. I mean, really, Ryan's a bit too modest, but he has made a huge difference with the Toronto Police Service Board. And I worry, because I see this reaction, for example, when I've gone around the country talking about Gladue, is people outside of Toronto kind of say, well, that's okay, you can do it in Toronto, but we don't have the resources to do it except in Toronto. And I really hope that that's not used as an excuse, because you can't have effective governance, especially with a $5 billion budget enterprise with the RCMP, unless you have full-time people as well as part-time people that can fulfill representational interest supporting them. So we don't have that. So that's one problem. Another problem is the Minister of Public Safety, even now that emergency preparedness has been hived off, has too much on his or her plate. So I think we need to move to one minister who has responsibility for the RCMP. Perhaps my former colleague Anita Anand, after she fixes the military, might be a good candidate. So you have that. And then I think finally, you have this kind of melange of local committees that can have some influence over the detachment, but the detachment still reports up the chain to the provincial commander, but the provincial commander also has to fit into a national structure. So I think that, Alberta's local police committees look good on paper. So do similar ones in Nova Scotia with respect to the RCMP detachment. But I think one of the things the Mass Casualty Commission has heard is that it's not really working. And of course, Justice Opal looked at this stuff way back in 1994, and I believe he's given perhaps the first talk that you've had. So we've been trying to change the RCMP for a long time. And the RCMP is very difficult to change. There's also, and then the last thing I'll say, is there's the fact that the federal policing mandate is in need of a lot of of assistance. And so it's always going to, I think there may be a tendency for a national minister, a national board to focus on the federal policing mandate, which is very important, matters like national security, money laundering, protective services, and perhaps the local provincial policing has tended to get lost in the mix. Having said that, I don't want to be totally negative. And if contract policing is retained, I would look and evaluate what's happening in the Yukon. But you compare what's happening in the Yukon with what's happening in the two other territories, and we know, and the Rcmp Civilian Review Commission is looking at policing in Nunavut to its credit. But we know that it's a bit of a mess. And so we need to find some way, if the Rcmp continues to be the local police, to ensure that this kind of complex, iterative process of governance that Ryan spoke about so well can also play out there.
Kent, thanks for that. Ryan, this one's for you. The question is, civilian oversight at the community level will require orientation, training, and associated costs for meetings. Who's responsible for the costs, the timing, the responsibility for material, and ensuring civilians are properly orientated to understand responsibilities, and who's paying for the cost for municipal regional oversight?
Great question, and thanks, Kent, for your grade. I'll always take an A from you. I'll talk again about the situation we find ourselves here in Toronto. So the way that the budget process works every year is that there are actually two budgets that the board here in Toronto looks at. They look at the operating and capital budget for the police service. That is the billion or so dollar budget that people talk about, and that is the services budget to deliver police services through people and through capital equipment within the course of that fiscal year. The other budget that generally gets much less attention is the budget for my office, and that's the board office budget. And so that pays for the salary of the staff that we have here, and it pays for other expenses associated, as the questioner asked, in our ability to run our governance function, whether that's board meetings that happen almost every month, whether it's our policy development work, whether it's other community-based engagements, and a myriad of other things, including legal advice that we get, because don't forget, the board is also the entity that gets sued, as opposed to the police service in at least the civil context. And so that budget is a drop in the bucket, some might say, as compared to the $1 billion that it is responsible for governing and overseeing. But that is a budget that goes to the board every year for approval. And then, as required by the Ontario Police Services Act, it heads down the street to City Hall, where City Council has final approval of the overall budget. Unlike the board, they can't get into individual line items, but they can get into the overall dollar amounts. And so that's how we pay for it here. And all of that, of course, comes from the municipal tax base.
Thanks, Ryan. Kent, oh, go ahead.
Can I just wait in on the cost issue? I mean, one of the examples is I think we have to convince, and it's probably convincing first the federal government and then the provincial government, that getting governance right and spending on good governance will actually save you money in the long term. And so, with respect to G20, we all should remember that there was a 16.5 million class action settlement as a result of what happened in Toronto in 2010 with over 1,000 people arrested. There were also countless reviews. And so I think we have to convince funders and governments that if we invest in a more ex ante outcome-based, measurable governance process, like Ryan talked, one of the results is we're going to spend hopefully a little less on this whole array of ex post accountability, which, frankly, are definitely run by lawyers and end up really, really costing an awful lot. So, I mean, although Ryan and I are both graduates of probably the most expensive law school in Canada, we're actually, I think, and I won't speak for Ryan, but we're actually saying that if you get governance right, then you will probably have less legal bills to pay when something bad happens. And then finally, I mean, I am aware with the Rcmp's new collective agreement that this is really driving the concern at the municipal level. And I do have sympathy for local politicians who are saying, look, we just don't have the money. We don't have the money even to try to experiment. We're just living year by year. But one of the reasons why I wrote the book is that's kind of business as usual. And I think that living year by year is not getting us the outcomes that we actually want. And so this is why, and whether it's a province or the Fed or some combination of it, my advice for the federal government would be to think about facilitating exits from contract policing or a new mix between, because I don't think we can end contract policing overnight. It's just huge, and we need to get the balance right. But it would be nice if the federal government said, look, we're not going to gain money here by simply taking the federal subsidy from contract policing and putting it off to try to pay off the deficit. That we need to make that revenue neutral. And I think that for provinces also, they need to recognize that they may have more of a taxation base than especially rural localities, and that they have a role to play transitionally. And then if we're talking about this 5-10 years out, in an ideal world, you're going to measure by outcomes. And you're also going to have a governance system that's not simply in silos, because we're spending so much money, and Chief McPhee talks about this, right? That we're spending so much money in all of the silos because they're not talking to each other. And so we need to find a way to drive this by outcomes and to have the money go to where it is most effective.
And Doug, sorry, part of your question also talked about training, so I'll just quickly answer that. Again, here in Toronto, our office delivers training to every board member when they assume their role as a board member, and we also have been looking at instituting ongoing training sessions on different topics, governance, but also more specific topics to the Toronto policing context. To our board members. But that's something that we undertake. We develop ourselves or with partners, and we deliver ourselves. I do know that there has been talk, and there's some good work that the Ontario Association of Police Services Boards, the Canadian Association of Police Governance is doing, to Ken's point, to put a little bit more spotlight on the need for board members to have that infrastructure of professional support and the training that goes along with it, recognizing that there is a price tag at the end. But as Ken said, I think one worth its weight in gold.
Ryan, here's a follow-up to one of the earlier questions. Does the Toronto Police Force do a satisfaction level survey by the local residents? How do you measure the satisfaction of policing service is actually working?
So the answer is yes, they do. They generally do an annual survey of residents of Toronto on a host of topics, including community satisfaction with the delivery of police services, both within the local area that the survey answer lives in, and also more broadly on some more broader, more systemic issues. I'm happy to say that in the last 2 satisfaction surveys that were done comparing 2020 to 2021, we actually here in Toronto saw a 5% increase in satisfaction from 80 to 85% with the Toronto Police Service. That doesn't mean that the work is anywhere close to being done, but my hope is that the sort of healthier role that governance and the role of the board is playing, interfacing with communities, helping to translate their values, their needs, their expectations, the relationship, the modern relationship we've created with the board and the chief around information exchange and critical points and examining the impacts of policy so that it's hopefully the best recipe. I think all of these things hopefully are contributing to that level of satisfaction, but it's a value that we continue to pursue.
Thanks, Ryan. Kent, which policing agency has the best model currently for police governance and civilian oversight in Canada?
Well, I mean, you know, Ryan's going to think I'm sucking up to him, but it probably is the Toronto Police Service Board. And, you know, partly this is because it has been under the critical lens of first Justice Morden and then Justice Epstein, who I assisted as her research director. So I think that, you know, one of the things is that when something goes wrong and there's critical oversight, it really provides incentives and hopefully guidelines to up the governance game. So I would think that this is, you know, but it's easier, I think, because it is just a municipality. Now, the one thing I will say that I have said previously that's critical about Toronto's approach, although I do think certainly in terms of having a well-resourced and educated board, it's the best, is that I worry that the community safety and well-being plan that has been drawn up and is required under our Police Services Act is not, on its face at least, sufficiently integrated with the police. So one of the, you know, and this goes to a governance challenge, which I think is a long-term governance challenge, but one that is worth thinking about. That, you know, for a long time now, there's been a lot of enthusiasm about hubs, multidisciplinary, multi-agency hubs, started in Prince Albert. Again, Chief McPhee is one of the architects of this. But I think we now need to say, how are we going to ensure that governance catches up with the fact that we want to break down silos. We want the health system, the mental health system, to talk to the policing system, to talk to the housing system, and to talk to the education system. And although SAFETO, which is the Toronto Police, the Toronto Community Safety and Wellbeing Plan, which is supposed to last for 10 years, which again strikes me as too long, is supposed to break down these silos. I think it is an underperforming plan. And in my book, I compare it with a plan that was devised by civil society partners like the Gerstein, Canadian Civil Liberties, and Black Lives Matter, called Rethinking Community Safety. They're about the same length. They're only about 20 pages, but I would like the sort of creative and evidence-based thinking that is seen from the civil society. I think that needs to inform police governance. But I recognize, and I don't expect Ryan to respond to these criticisms, but I recognize that even as the Police Service Board tries to reach out with advisory committees and so on, it's still dealing with silos because the Police Service Board is a separate entity. It will have some representation from Metro Council, and thankfully the mayor sits on the Police Service Board. I think that is also important. That was something, frankly, missing in Ottawa during the Freedom Convoy. The mayor was not on the police service board. I think we need to, 10 years out, say what is the optimal way to govern community safety, of which the police will be a key partner, will remain the 24/7 response. I'm not a police abolitionist, but if you look at rethinking community safety, it's very interesting that even Canada's Black Lives Matter signed on to that report, and I would commend it to anyone looking for a source of creative ways to detask the police with respect to certain areas. But again, with detasking, like with contract policing, this does not mean police abolition. It does not mean that the police are not there. What it means is those with the proper training take the lead with the police there if something goes wrong, or at this point it becomes a matter where the expertise of the police and the powers that we give the police are necessary.
Yeah, Doug, if I can just jump off a couple of points Kent made, and I certainly heard him on SafeTO. I will perhaps just highlight a couple of components that I think are important on the silo point. So the legislation that mandates in Ontario that municipalities have to create community and safety and well-being plans also mandate that those municipalities have to stand up an advisory group that includes the host of participants that are responsible for policy and delivery of services. So that includes the police and the police board separately with seats on this advisory group. It also includes public health, the education, school boards, obviously the city and others. And I know that, you know, the work of SafeTO was the product of that development and that governance, but also the product of community consultation. But let me give one example of an area where I think some of these silos are being broken down in more real time. And that is an MOU that our board entered into with an organization called Medenta and a group of Somali mothers that came forward asking for improved relations with the police to address gun and gang violence within their communities. And several years ago, this MOU was entered into, and it specifies the obligations on all of the parties, including the Toronto Police Service and Board, in delivering educational sessions to this group of mothers on a host of topics related to public police interactions, getting to better know and develop better relationships with our community neighborhood officers in the divisions where these mothers live and their families live. And we have seen lots of work still to be done, but we've seen others come to the table as a result of that, including our city participants, social services, and others. And so we've created a de facto structure out of nothing, really, based on the good work and leadership of these Somali moms to do exactly what Kent talked about and break down those silos. So I think it's a model of sorts that can be applied, at least philosophically, to other areas, and I think very much in the context of community safety and well-being.
Kent, this one's for you. One of our attendees asks, I'm curious how you measure success in oversight. What's the measure? More charges or disciplinary action against police officers? Fewer complaints? A reduction of civilian deaths by police officers? How do you measure oversight?
Yeah, well, I mean, I think you need to look at each incident to see whether it commands public confidence. Does the sanction line up with what the problem is? But I do think that long term, you need to take an outcome-based approach and look at things like police deaths, police involved injuries, number of complaints, because one of the problems is lawyers and accountability mechanisms are good at kind of judging a case based on all its facts. They're not so good at saying, how do we ensure, even if there isn't liability, but especially if there is liability, how do we ensure that this doesn't happen again? And so really, my whole book is calling for more governance, because I'm frustrated with the repetitive nature of some of the problems that we're seeing in policing. And so I think we need, as Ryan said, it is two sides of the same coin, but we need to take the results from civilian oversight in individual cases and think about how we can avoid the need for that the next time.
Ryan, do you want to add to that? We'll give the last word to you.
I would just double down on what Ken said and say that boards, commissions, and other oversight bodies need to develop the capacity to be data-driven, to look at trends as opposed to just individual cases, although those can certainly be illustrative. And I'll tell you, here in Toronto recently, that was, and I know some would argue too late, but that was the approach taken to strip searches, where after reviewing and considering the input and the recommendations of the OIPRD in its systemic review report, and after engagement between the board and the service, the chief implemented precisely that data-driven approach, which has seen a very significant reduction in the number of strip searches with ongoing monitoring. I think that same approach needs to be taken to a host of areas. That requires capacity, that requires investment, and also an understanding of roles, that boards and commissions should be engaged in that work. Here in Ontario, I think a lot of people are very interested to see how the soon to be, when the Act comes into force, Inspector General of Policing will play a role in creating some of that data-driven, outcome-driven framework right across the province. So, as I said at the beginning, an exciting time, but if we take this modern view of governance and oversight, I think we are certainly headed on the right track.
And that's all the time we have for questions this morning. Thanks to all of the participants on the webinar who submitted their questions. And if we didn't get to your question, please visit the Future of Alberta Policing website, where there is additional information. Thanks again to our panelists this morning, Kent Roach and Ryan Teschner, for sharing your expertise this morning. It was very informative and enlightening. Thanks again. Attendees, thanks for joining us as well. And we welcome you to join us for Wednesday's webinar, an opportunity for evolution in Alberta's policing. Take care. Enjoy the rest of your day.